Hey, 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 Ted, settle down. Settle down, boy. What's wrong? What's wrong with you? Settle down. Hey, APZ, I'm trying to get the dog to settle down. Settle down. Hey, come here. What's going on? Hi, servant. Hi, 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 hi. How y'all doing? Hi, y'all. This gonna be a noisy and fast. Because I got my dog is on the rampage and I'm dog sitting my other dog. Hey, look who's in the chat. Lisa Tate, what's going on? What's going on? How y'all doing tonight? How y'all doing? I don't know what's his problem. I really don't. He don't want the other dog over here, basically, because he's so territorial and used to being by himself. Hey, you need to sit down and settle down. So and Fancy is too scared to come downstairs, so she's staying upstairs. And Teddy ain't feeling this, y'all. Hey, Beauty. Beauty is her name. How are you? I needed to come in and do some chitter chatting with y'all. I wanted to see how many of y'all are in y'all feelings about this YSL. How much are y'all engaged in it? How much time of your life has it consumed? Y'all, how much time is it consuming of the Puff Daddy situation? Sean Combs, baby, I peep in on it. You know I'm a serenade you. I got you. I got you. But I came in so y'all could talk to me. Give me something to converse on. Yeah, you just chilling. That's what's up. I'm glad you caught my live too. I'm glad you caught my live. But I'm peeping in as I'm working, you guys. I'm peeping in as I'm working, and I was like, holy cow. Miss Brown is in the house. I love you. I love you, Leisha. I love you, Beauty. I love you, Servant. I love you, APC. Yeah. I don't have nothing planned as usual. I kind of just roll with the flow and bring the shits and giggles where I see fit. I didn't sing to you because you might get used to this and you may want a song every day. And you know beauty will get me because I mess up every word of a song. Yes, I do. I just turn it into what I want it to be or what it should be. I change everybody lyrics. I'm like, that shouldn't go that way. That song should go this way. Not that way. I don't like that way. We gonna put out a new song this way. Remix. But listen, y'all. Listen, y'all. I see a whole lot of people feeling so bad about that one guy that got arrested. I'm gonna try to bring up his picture. Hold on. This one guy goes, oh, wait a minute. I don't think I want that. Oh, hold on. Let me do this so I don't get an echo. I see a bunch of, come on, come on. Okay, there we go. I see a bunch of reruns being played out here. I see a whole lot of people, that cares about what's going on in the courtroom and how the courtroom is ran and and everybody's opinion. Y'all, I even seen some people in the chat that I would have never thought, like, listen here, y'all. You got to take a look inside these chats, right? Because they're part of your who not to mess with a list and who is okay to mess with. Man, I seen some people, boy, I was like, ooh, child, you messy. You messy as hell. And you know it don't start or take much to start messiness, right? It's like in the I'm waiting on this other screen to come up. I don't know, it's my computer running slow, but it's like all it takes is for one or two people to trigger off acting like crazy inside the chat, right? And then of course the rest will join in, and then the chat's just there. I don't know if they there most of the time. I'm gonna say it's a half and half. It's like 50% of them are there to learn, and educate themselves. And the other 50%, when I tell y'all this one chat literally talked about everybody that comes on that stand. And y'all know I'm kind of crazy and I love my laughter, right? And I'm sitting there and I'm laughing. I'm like, there's no possible way that these people, this group of people, right, could be assuming what is actually going on. The only time that they pay attention, I'm talking about the silly group. I guess they call them the trolls, right? Where, they say just crazy things. And there's no way. There's only time that they pay attention, the silly group, is when it's something that I think just catches their ear off of a moment of, oh, did y'all hear that? And then they kind of tune back in to the case. But everybody from that detective, female detective, what's her name? Gray, I don't write the names down. Her, Detective G, that lady, to Detective D, the dentist guy who just got demoted off of the stand. He got, I'm gonna use one title that I saw out there, expelled from the stand. On to the other, I guess, FBI lady or whatever that was just on there today, right? They talk about everybody come on that stand. Everybody. And I was like, seriously, people? When they be doing that, I be wishing that the camera would pop on them, just magically pop on them. I want to see how you look. I want to see what you're wearing. I want to see where you live. I want to see what you're driving. I'd be like, it's insane. It's totally insane. What tends to catch me off of guard and surprise me is I didn't really realize how many Black Americans were this interested in the law. Caught me off surprise. Totally caught me off surprise. So I was asking myself, is it that it's over 20 plus people that's interested in the law, but they don't practice the law? They won't make it their profession. I don't get that. Ted, shut up. You know what it is? Fancy speaker downstairs. And sent me a vocal dress. Oh no. Hey, hey, get up here and knock it off before I lock you in the laundry room. Now sit down. Hey, Keandre. Hi, grandson. I said sit. Nobody even picking at you. You ain't bad. You ain't had a fight since you've been born. And so go sit down. You don't even know how to even do a fight stand. Go sit down somewhere. Teddy just thinks he's bad, right? He's not bad, right? He's territory, not bad. But I don't know, y'all. What do y'all think? What do y'all think? And what are y'all thoughts about this whole trial? Now, um, I watched the one guy come back to court. If I'm not mistaken, isn't that the guy, the Moonkie Toonkie guy, who got rid of his attorney? Didn't he say I didn't need an attorney? Or was that maybe the guy before him or whatever, right? I don't know. Either way, he has an attorney up in there, and they show up to this court proceedings because I guess of a motion that was filed, um wanting to remove his, he violated, I guess they say, his paperwork that he signed on things that he was supposed to do in the courtroom on behalf of this freaking state, right? And somehow, maybe he thought that he was gonna pull it off like that Woody boy. I don't know. However, it didn't work in his favor. He walks up in there, and the judge says that, in a sense, this is kind of like him committing perjury on the stand. So I don't know. Now, I watched where the judge got on her Zoom. True, I guess this is his probation officer, right? Man, y'all, this boy got a rap sheet longer than my damn shoestrings threaded through my shoe. I, I'm trying to understand the empathy that people share amongst situations like this. I'm confused whether if they are empathizing quite a bit on the simple fact that it's about the color of the skin. It's too many ninjas, in jail. But me, on the other hand, did y'all not hear his rap sheet? And granted, they were back from 2004 or something about 2005, and then somewhere in 2000, and I think the latest of what they had them on or something. Distribution of narcotics, y'all. Now, I try to look at that with an open-minded standpoint of view. I do. Okay, you get out there, a lot of our ninjas, this is what they're calling people. So I think I should use that word for now until somebody make me upset. But this guy, hold on, let me pull it up. Rap sheet, y'all. He's literally been out in the streets for a long damn time. And you know what? His attorney came back. This is the monkey tone. Let me pull it up. Hold on. Let me see if I can get this shit up. Hold on. I don't even know how to spell it. Let me see if I can get it this way. Okay, I'm gonna let y'all hear this. I'm gonna let y'all hear this shit. See if I can find one that's kind of explaining it all. Okay. This guy here, Beauty, listen to this. I'm gonna fast forward a little bit. I'm gonna show it to you, right? Let's see. Let me know when it comes up. Girl, the boy walks up in jail knowing he did not follow through with what he signed on that paperwork, right? At one point, I kind of felt like him and that Miss Love had a relationship at a level where there was, I don't know, previous conversations from them. If I'm not mistaken, this is the guy that they brought into court that he alleged was really, really sick, and his doctor, they got his doctor on the phone or something, and they kind of okayed for him to come to court. Well, he seemed to be doing a whole lot better, though. I'm gonna share the screen, so 1 second. But this was the craziest revocation like ever. And you had his attorney really, really put up a good fight. He really did, you know. He went into, explaining like he understood it, but he was kind of under the impression, Monk Punk was under the impression that they were going to have further discussion with him to really explain to him what he was doing, right? And so some of it was clear, and it sounds like some of it just wasn't clear to him or whatever. And I guess he failed to comply. So I think that he had issued 30 years, but that time was upheld, so he can come out and do this shit for the state, and he's on probation. I think his paperwork said where he can elect, either you do this or we're gonna put you on, I think it was 15 years of probation or something, right? I'm just trying to call off what I remember. I don't watch it in depth like that, right? Because I'm not blind as to what it is that I'm looking at, and not to be judgmental, but hi, Sir Miguel. Hi, how are you, sweetheart? But I heard this boy's rap sheet. And granted, it may be some years in between where uh, that part of life to what they were doing or he was doing, it might have had slowed down for him. But what I did not hear was that in between downtime, where he worked at. I think he had some odd jobs or something, but I didn't hear them mention anything about sanitation for of Fulton County. I hear nothing about working in the cafeteria at the hospital. I didn't hear nothing about nothing, not even at the library, nothing. So his attorney comes back, to try to soften the pillow some more for him. And he started, you know how us ninjas are, right? If you throw in a line of babies, that will kind of help. He started saying he won't about to have a second grandbaby, and he's got a new grandbaby and the grandbaby and the kids, and he take care of his kids, and he does this and he does that. Like I said, I'm not trying to be judgmental, but there is this thing in life where you have to make choices. Now, somewhere down the egg and sperm stream, and you have a daughter or a son, you have to know that it's a possibility that they might, okay, have some children, and you might become a grandparent, you know. You have time, you have choices and time to prepare on what you want right for your life. Now, I've listened to quite a few of witnesses come through to do their testimony on the stand under oath, pertaining to these guys that are sitting in this courtroom on the defense side. I went and I kind of would peep in on what people were posting up on their old Instagram posters when they were like what, 9, 10, 11, 12, 13, 14. These are young fellows out there, and they say that developed a gang. You see them with guns. You see them, so trying to interpretate what exactly is a gang and how it is developed is such a wide meaning to it. However, this state here seems to have developed what they presume is a gang. We won't call it as such until something drastically happens to you or your family. Then we can kind of see that light. But until it subsides from harming any of your people, we look inside this window of what they're trying to prove as dust on the table. Huh? How can it be? How can it be? There's a whole lot of people out here, y'all, that are from the streets. And I'm talking about ninjas. They know what it is. They know how it is. They know how it is developed. However, closed mouths, as they say, sometimes have a little bit more life to you. You just gotta be quiet and let the people do their job. But this guy here shows up to court, and as I can remember, he was the one that was very ill, and they pulled him in there, signed the paperwork, ended up with 15 years of probation or some shit. That's a long damn time. However, being on when they give you the probation, right? People like me would think that, okay, that means that we will revoke that if you go out there in the streets and do something of a similar that got you incarcerated in the first place. However, to me, this wasn't the case. This case here was about, you and about how he would testify on the stand. Understand. Y'all want to see Fancy. Let me show y'all Fancy. Right. Come here, Fancy. 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 Come here. Come here, girl. Let me see if I can show y'all Fancy right quick. Hold on. Yeah, she over there being busy. But anywho, let me let y'all listen to why this guy. Hey, settle down. I told you to knock it out. Leave her alone. She gonna bite you back. Now lock it up. Go upstairs. Go. She gonna bite you back. Listen, y'all.
Certified copy of the conviction, for your honor, with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's section 4 and 5 of the plea agreement as it relates to the factual acknowledgments that the defendants swore under oath during the plea that he reviewed, then initialed each one of the factual acknowledgments, and then signed that he again understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. as everyone is aware, Your Honor, witnessed it, and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea
Yes, he
agreement.
do, Sheila.
during the
This dog
testimony,
do not
we're gonna
like
focus on the
nobody
reason
else in this
to,
town.
go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation, Your Honor. So this time I would tender State Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant. If Your Honor wants to preview it or wants to be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the.
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that. Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
Yes, I'm very much aware of that. The transcript obviously is not ready as we're still in the midst of the trial. I
Right.
didn't want to overwhelm the court reporter who has been doing nothing but probably working hardest out of everyone in the courtroom. So I knew Your Honor
Right.
could take judicial notice.
Thank
and
you.
rewatch it. Can I approach it?
You may. And can you try to use a mic, please?
Yes, Your Honor.
Can they go to the court reporter?
Nothing further from the state at this time, Your Honor.
All right. Mr. Wright,
Your Honor, may I remain seated or?
it's probably,
You see
You
that?
can.
I
It's
don't know,
really easy
beauty.
to
Hold
hear.
on, let me pause that. So, wait a minute, why is it not showing on the other screen? I wanted y'all to see because this guy here, he did state, when they asked him when he was up on the stand, she had asked, I remember that attorney, that Love, the state Love, right? I remember her asking him a question, whatever, and he was like, and it was something pertaining to about jail. And he was like, I go upstairs, Fancy. He was like, I don't care. It's no big deal to me. I done been there. Like he literally like, do what y'all want to do. It doesn't matter to me. Now, mind you, when I heard his attorney speak for him and started throwing everything, including the kitchen sink, at the judge to savage him, a little bit, that just came to my mind. That literally came to my mind. Like, I don't know if his attorney actually remembered when he said that. Hi, Calder. Calder Bear's here. What are you sneaking up here for? Hi, baby. Hold on, y'all. Hold on 1 second. Hi. Take Fancy up, because I'm sick of them. Look. Say hi, Calder.
You want me to take her out?
Yeah. All right. I'll be up in a little bit. Yeah. I'll be up in a bit. I'm chitty-chatting with the ladies for now. Here come Teddy. Make sure they don't fight. Calder snuck in on me, y'all. She must need some groceries. Yeah. Okay. So I don't know why y'all can't see it. I didn't share. Let me see if I stop sharing. Let me see. I'm gonna bring it up again. Stop. Stop. Okay. I'm gonna try to share this again because I want y'all to see his face. Okay. I'm just screen one. And I know y'all probably seen this today because there's a lot of people watching it. However, I'll never see none of y'all in the chat. Nowhere. But Let me give it a second for it to come up. And let me get rid of this. I don't know why this won't come up. Come on, come on, come on, catch up. Well, while that's waiting to catch up, 'cause I don't know why it's not catching up on the screen, but he has like this smirk on his face, like he kind of knew it was gonna happen. He kind of knew that he didn't satisfy what Love wanted or Hilton wanted. They filed a motion to revoke, and he went up in there like, okay, it is what it is, you know. So he ended up getting, I think it was like 5 more years or something on his probation. Now, I'm not sure because they took him back into booking, right? Out of the courtroom. So I'm not sure if they're going to allow him to make bail now again or whatever and restart his probation over, and of course adding on whatever the 5 years that she had mentioned in the courtroom. I don't know. Let me see though.
Okay,
That way.
I think I'm on. Your Honor, if it'll please the court, I believe, and I have already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yeah.
So those are sort of resubmissions
Okay,
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
what is your exhibit 6? I think I
Well,
only got
exhibit
5.
6 is the one thing, and that's just a listing of my
Okay, so
emails
he
in
had to do
December.
the 5 years.
That's this one page.
Yes.
Okay, it didn't have an exhibit marker on it,
I'm sorry,
so
Judge.
that's fine.
And, so succinctly, I thought it best to submit these exhibits. When you look at exhibits 1,
And those are admitted for purposes of this record, which is the probation revocation matter.
thank you, Judge. When you look at exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours. And that's one reason I wanted to make sure that the sort of the cover page along with.
So I believe what he's doing now is trying to explain to the judge that there was communication, but there was a lack of a communication in their email timeline. That's kind of what it sounds like to me that he's saying. One was getting back to the other, but unfortunately he was in a court hearing on the day that Love had emailed him, so he didn't get back to her as expeditious as he probably should have because he was in this courtroom dealing with a court proceedings. So I think that he was looking for the judge reaction to that, to investigate that a little bit further, to kind of see, is this where things went wrong at, you know? But the judge, she didn't even expound on that at all. You know, it's like, well, I couldn't, and I was in court, I was here, blah, blah, blah. However, you can tell that the judge, when they put that motion in and she had a day to probably review it, and what she said at the end based on her analysis about it was like, well, this kind of like, he did perjury, on the stand. And technically that's up to 10 years, right there. So I think with her having that time to read over the motion, a decision was pretty much already made. And she also said on the stand that, I was here and I witnessed it, basically. So it was like, save me the violin, save me the violin. That's kind of to me like what the judge was saying. Now, in the law and crime chat, because I peeped in there a little bit earlier at work, right? And you can see the chat room all in a disarray, man. They was livid, right? Because yesterday they felt that, oh, okay, the defense, got some points for the day. They felt that the judge did very well on her judging that yesterday, right? And then today they was like, what the hell? Didn't it come back with this whammo? When in fact, I think that a lot of them may have forgotten that, hold on, that motion was put in. And I don't think that people thought further ahead onto this was going to happen at the end of the court today, right? Because it happened. Y'all, the law and crime chat room be cracking me up. Let me let y'all finish listening.
With the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that the second one, defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only two exhibits or the two drafts which occur on the 27th. However, it's important to know that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right.
Now,
And I recall we discussed this during the trial of this, the ongoing trial as well.
yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see defendants 3 and defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was defendant's exhibit 4 that if you look on defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you notice, I never respond because I'm here, I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on defendants 4, use this.
But are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So, ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that that statement was false. That is,
I'm not sure about that. That may be your contention, but
well, we would contend to the court that where my actual email defendants 2 clearly denoted that
it does not. That is up for debate what that denotes.
it is removed from all the drafts and then ends up back in,
That is true,
so
but you're,
So if it was removed from the draft, this is where I got confused at now. Somebody help me with this one. Then why would the judge says that he's correct when he's trying to show the judge that there is a possibility that something is invalid, that something was done on the crooked side, like this was not there, then it was there, then it was not there, then it was there. And the judge clearly says, well, okay, that is true. But then she goes on to say that what was there, to his knowledge, was up for debate. And the judge was saying, no, it's not. It's not denoted as that, you know. So that's where I got lost at with the judge, because I'm like, wait a minute, who, what? Let me replay that. Replay that.
she knew that
She
that
knew.
statement was false. That is,
I'm not sure about that. That may be your contention, but
well, we would contend to the court that where my actual,
See, so how does she know if it was true or false? I mean, I guess, they have to bring Ms. Love back in, ask her under oath. Did she know? But that kind of went overlooked, and he continues to try to go into describing to the judge exactly what went on. And it might have went on without the judge knowing this, because of him saying things were input and some things were output, then it was back input and output and all over the damn place.
email defendants 2 clearly denoted that
it does not. That is up for debate what that denotes.
See, she said,
it is removed from all the drafts and then ends up back in,
That is true,
so
but you're,
why wouldn't the judge want to know for sure if what he is stating was removed? If she's saying that is correct, when you want to know, I'm just asking y'all, when y'all want to, wait a minute, what are you talking about? When you want to have the Miss Love back in there asking her, well, did you remove anything that you know that was there, and you knew it was false, or what? It's some weird shit. That part was weird to me.
your response on your defendant's exhibit to item, what is then item number 4, does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways, but I understand what you're saying.
and just so
You maintain that the two of you both missed the fact that you signed, or your client signed a factual acknowledgement that included item number 8.
correct.
And then when Ms. Love read it out orally in the court,
What was number 8? I
and
forgot.
Mr.
I
Sledge
didn't.
one by one said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation he contradicted or he refused to acknowledge during the trial that item number 8, it is the entirety of disavowing factual acknowledgements, etc. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5. Sentencing acknowledgements, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss.
So Moncton had an attorney that knew that all of these items were up in this, I'm gonna call it docket motion, whatever this is, right? And he only addressed item number 8. He didn't have nothing else to bring to the table for the boy's defense on all of the other items. All of the other items. And then the judge sits there and says that all of those were read to him. And he clearly stated that he understood them all. He understood them all. I'm like, hold on, wait a minute. All he brought was an argument for one item. Oh no, buddy. He should have been ready for it. He should have seen that coming. And as an attorney, he probably did see that coming, but he didn't have an argument for the rest of the items. And that pretty much is what stuck it to him. Now, had Moncton not had all of those other items up underneath his belt where he stated that he clearly understood, right? And it was just item 8, he might have survived. He might have would have survived that. But if you got 20 items out there, you don't just build an argument for one. You got to be prepared to have arguments for all of them. So I think that, in my opinion, that his attorney, I'm just going to be nice about it and say did the best that he could. But he's the attorney, because I know I would have been sitting over there saying, well, wait a minute, what are we going to say about this one? Well, what are we going to say about that one? But maybe he thought that just addressing item number 8 was going to sustain for all of the rest of the items. I don't know.
That's it. And he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual
There's a whole lot of
acknowledgements,
compounded
there are
stuff.
still however many other ones that added up to
Right.
that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen, but that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However, in evaluating my client for the purpose of this hearing. I don't think the state is denying that that is something that it was understood. Understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after what was that, December of 22, was now for the first time being drilled or asked questions rather as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times.
Boy, he was working it, boy. He was really trying to sell that. This boy done been back and forth and in and out of somebody's courtroom throughout the years of his living, right? And at some point, the more you go, the smarter you should be when you get there, especially when there's a bunch of paper being presented before you. Now, my question, I guess I do have is, because I guess this was his attorney, and I'm not sure, he speaks as if he had been around for a while, and the attorney didn't read all of this. Where was this attorney at when Montouk signed this stuff? Did he not have an attorney available? I'm asking the chat because I don't know. Did he not have an attorney available before he signed this, or was he so excited of the presentation to say, well, I'll take the 15 years probation? Like, which one was it? Was he excited about that and glad not to be, but incarcerated for 30 years? And yeah, I'll do it. And this goes along with saying that signing your legal documents of purchasing a home or purchasing a car, hell, purchasing a damn attorney. There's them little small prints down there that a lot of us just don't like to read. They're important to read them, because just because it says, or it is, or it was up here in them big old black letters that we can see, and then when you get ready to sign, the man says sign, and then you see that down there, he goes, oh, that's just some type, disclosure, none that won't hurt, that won't hurt. But people tell you anything. But bring your magnifying glass to you when you go shopping and you got all the papers in front of you. Be like, hold on, I need about 30 minutes. And start highlighting them words that's like, whoa, wait a minute. This sounds like it's contradicting something upstairs that I just read. So let me get the clear understanding and make sure that the comparison adds up, because those are just a breakdown. Those are your little breakdown little points at the bottom of that page, but all it takes is an E as an R added up in there. It'll change the whole configuration of the meaning of something.
And shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say.
I hear him talk about none of this boy illness. because that could have had, some weight to it. I believe the judge was aware that, he was sitting up in there under the influence of a lot of medication and everything. So his breakdown on the stand, that could have had, some play into his character as well, to the way that he was answering certain questions. He was annoyed, he was stressed, he was, but I mean, the attorney, is trying very, very hard. So
Something different than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness recounting things that happened quite some time ago, and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive.
I just I had to snicker. I was tickled by that part. But listen, he says that this young man, should not be, judged or held liable for a lot of things that he said back then, as opposed to what he's saying now. It sounds like he's contradicting himself, or, he didn't lie, okay, on some things, right? Because he can't remember. It happened some time ago. Now, I just actually watched that detective that did the work back then. What's Gaylor, the female? I remember her, quote unquote, saying one or two, maybe three times that, I can't remember that far back. I'm not sure. I also remember that detective, one of the black detectives or whatever that was, I guess, in the room with Detective Gaylor. He said it before. This FBI or whatever, this profession of the last lady that was just on there today, right? She said it. She said it too. So I guess it's possible and okay for those witnesses, which the judge called them expert, experienced in what they do, right? To not be able to recollect some things that happened over a decade ago. But these guys that are in here with defense attorneys should be able to know what happened years ago. Make it make sense. If they can't remember, what the hell makes you think that I can remember? It's weird. They get to not be able to jog everything in their memory. But when you're in the hot seat, you need to be able to jog everything in your memory, or shit can happen. Or better yet, I guess with his luck, he probably should have did I mean, which he tried to do at some point. I remember seeing him one day, and he went to that I don't recall mode. And I think now that I remember him using that tactic, right? Maybe that's where Love and Hilton and the rest of their gang over there felt like, oh boy, we might as well get ready to draw up this motion right now to have his probation revoked. I think when he started that show right then and there. And then I remember in the Law and Crime chat when I peeped in, a lot of them was up in there saying that he on the stand trying to pull a Woody, because he was doing that day. I can't recall. I can't recall. Well, I think that that's exactly when, at that point, where he end up having that Miss Love started to scratch her head and get herself prepared to have him locked back up. I think that after the whole shit show with that little Woody on the stand, I don't think they came to play no more. That it was like, that's it. None of them are getting back up here to do this anymore. And, oh, child, just listening to little Woody ask the judge, I can't be recharged, right? I'm not going back to jail, right? So I could say and answer this. And she's like, You're not going back to jail. Nothing is going to happen to you." And that's when he completely just let it all out. And I was like, how is this possible? How is this possible? Because of his immunity. Okay.
There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
That's not my speakers, y'all. That's
All right.
their speakers.
Anything else you want to present?
Your Honor, not at this time.
All right. Can the state, give
Okay, so
me,
now I'm gonna fast forward because I want y'all to see the Zoom meeting. Okay, here we go. Listen to his rap sheet. Wait a minute. I was like, oh my God. Okay, let's go ahead.
Okay, I'm trying to get myself on the video. Oh, I know. So that it's not a disembodied voice. Hang on. All right. Officer Jolly. Hello, Judge. All right, what is probation's, can you give me a rundown of Mr. Sledge's, criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's
The
lucky.
DeKalb,
Since you're only supposed to get to use it once, okay.
yes, so the DeKalb County case, 04 CR 24799, that was theft by receiving stolen property, felony, and a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005. I'm sorry, he used his first offender. The second case, 04 SC 23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine.
So
in
these
Fulton
are
County
all
was January
old.
3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138.
Now she shook her head. The judge shook her head because she was like, "Wait, how many first offenders do a person get?" And she's probably asked herself, why they give this guy all these first offenders? And you're only entitled to one. Now, is he only entitled to one in different counties, or what's going on here? And she just may be that judge that just may be looking into that, like what's going on, how he's getting by, who's he sweet talking, what who's making these backdoor deals possibly, or this or that. So it's almost like, we're giving you another chance. 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 When I hear something like this, what I'm thinking is, boy, we really beat down on these people, right? And yet then you can see where there's a lot of wavy stuff going on. They give them chances. They give them time. Okay, well, prove to me you can do this or you can do that, and I'm hearing that here, and I'm sure the judge is, she's hearing like, oh, okay, he's had some leniency a little bit here,
994, that is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with a firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment,
missing a felony?
one moment. That would be correct, Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on, so the 15 SC, and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them now.
Okay.
So that's pretty good, you know?
Are you looking about prior revocations or prior
What's going on,
violations?
Lady T-Bug, hey,
This present time, I
sweetheart.
don't see any.
You say
prior
it was
revocations.
terrible
If there
5
was
years?
one
T-Bug,
documentation,
do you think that she should have issued that or not? Do you think that she should have issued that? And another thing, T-Bug, where was his attorney? Because I don't watch it like every day like that. I may catch an hour or two here and there, but when they presented all of this paperwork in front of him before he signed, where was his attorney? Nobody read this over for him because his attorney literally sat there and said that as he was putting up his defense for item number 8. And then the judge recites that there were more items, you know, that she's sure he wanted to address, but he didn't address them. But his attorney admitted that he didn't see it. Why? Because he said that he was sitting in the courtroom. It couldn't possibly been that time. They had to have had this paperwork drawn up way previous prior to him coming to the stand. So who failed who here? And then you also had Monk Tonk. I heard him say, you know, did you understand everything that you read and you signed? And he said, yeah. He absolutely said yes. I think so, T. I didn't want to say that, T, but I was like, wait a minute, dude. How did all of this agreement get signed by your client who's on a stand as a witness, his signature's on there. And so to me, I would take that as you did run through this, but you failed to explain this thoroughly to your client. This is what's going to happen if you don't do this. This is what this item says. This item says if you don't do this item, then this item can come into effect, and bloom bloom blase skippy. I don't, and he did just that. He got on that stand. And at one point, he tried to pull a little Woody by not recalling. And like I said, I think at that point, that's when he agitated, loved them, and now they're drawing up the double whammy paper. Yeah, he wanted to get out to see his mom, but he also says that it made him no difference right now, whether if he was in jail or not. And then he puts that on the record, but then his attorney is sitting there saying that, well, he got grandkids and one on the way, and he, he takes care of them and he takes care of this. Well, you can't say that this is what he wants to do, or this is what is out there available for him to do, when he then sat on the stand and also said that he don't care if he goes back. It didn't make him no different. Exactly. And now I know he said that. So why do you think that this judge did not raise that to say, well, okay, well, let's postpone this until maybe she hears what Love has to say, whether if that original document was placed in and taken out, placed back in and taken out, was it sent to him while he was in court session and prohibited to respond to anything of matter at that time? Why the judge don't want to hear that? They met at the Starbucks. Miss Love and Monkton met at Starbucks. Honey, that's gotta say, this shit here, baby, this case here is just, I don't know how you just don't sign you just don't. They couldn't have not possibly went over all of the items on the stand. I have to go back to that one and watch it when he first took the stand. But this is the day that he was sick, because if that's the case, then his attorney is using. Oh, okay, because his attorney was using it. Him being, discombobulated a little bit, out of range. And this is why he was possibly, answering some of the questions this way and some of the questions that way. So I'm gonna go back to when he first took the stand. Yeah. Okay. When he went back to the stand to see if all of those items were read to him, however, at the end of the day, he signed it, he signed it. But I do think that since his attorney did have an argument on those bases, I think that to not be biased about it, even though I believe that the judge made up her mind already as is, he had oh yeah, okay, I do remember that one. You're right. But the judge then made up her mind when she had time to read over the motion, I guess over the weekend or so. Uh, Either way it go, Lady T-Bug, he just really screwed himself, period. Period. And I think for her to just to not show any biasm in front of the people, right? Allow Love to come in to readdress what Montauk attorney was saying, just to see, if there was some truth to it. Because if so, then maybe possibly she would recant her calling on this boy. He signed per his attorney, and that's messed up. So I don't know. They're not too forgiving either, though, T-Bug, on people that has a long history of a rap sheet that has a repetitive. I give you. I can say that I see some retaliation. I can see that. I can see somebody a judge being a little biased there. I can see that. However, his having a rap sheet, I he's been kind of doing or getting arrested for a similarity of crimes out there, and it's like, when you gonna stop? Even though he does show a period of time where he does kind of get it together. So like I said, I watched him and I listened to him. I think that I just got turned off a little bit when I start to see him put on the reaction to as I don't recall. You know, he's because he was starting to do that. And I was like, you know what? I'm not about to sit through another round of this. I remember him saying he ain't scared of nobody. I remember, you know, I watched I watched quite a bit of his testimony, but not all of it. I just got annoyed with it. Because it had started to not cause so much confusion, but it was just, to me, I just felt like it was a joke. You know, your life is on the line, you know. So what if the cameras are on you? This is not your time to be famous out here. It's not, it's just your time to either save your life, do what's right, you know, and I'm sure to his knowledge, you know, that he probably thought that he was doing what was right. But however, when you sign that paperwork, you say, watch the attorney testimony. Okay, I will. Let me finish hearing his rap sheet though.
It's a little bit, I guess, I'm having a hard time understanding what they meant by it.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession.
Now, this part right here, T-Bug, this part right here. Now, this is his probation officer, and she was there being able to pull up all of the incidents from 2004. She's got 2005. She's got this other year. How is it that she did not have this file to show what was in between it? Why do you think that that wasn't there? Um, hold on a second, y'all. Hold on. But answer me that though, T-Bug. You said that Love wrote the statements. They should have let him write it. I agree with that. I guess I can agree with that. But she did ask him if he understood, you know, do you understand everything? So and so, so and so. I believe I heard him say, I do. I believe I heard him say that. But I want to know about this. This is his probation officer. She's aware and she can recite back to the judge everything up until 22. And then the judge raises this eyebrow about, wait a minute, it's something missing in between here. And then all of a sudden, I'm watching Love up here whisper to the state attorney next to her, and miraculously, they are able to recite that, oh, there's a firearm by a convicted felon of 15 years dated back so and so, so and so. I want to know, why was this not in the system for his probation officer to align with the other incidents in that chronological order to the judge? Why did she not have it? And then you have the probation officer sitting down here looking as confused as I don't know what. Like what I'm thinking. How the hell y'all got that? And why don't I have that? So to me, it was almost like, pull this ace card out their pocket from. You know what I'm saying? I think that if Love and the other state rep up here would have not even mentioned any of this, then this would have caused the judge to withhold momentarily her decision making on whether to issue him 5, 4, or 3 years. You understand what I'm saying? Look, you gotta see these faces.
One documentation, it's a little bit, I guess, I'm having a hard time understanding what they meant by it.
Judge, while she's pulling that up, there is a
See,
13
all of a
SC
sudden they know.
423 out of Fulton County. It's a VGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th, 2014, which would be the predicate or basis for the possession of a firearm by convicted felon with
I
15
figured there had to be something else there. Okay,
Mm.
Sorry, I need to spoken sooner. I apologize.
appreciate it.
The probation officer was like, "Oop, okay. Where is that at? Why don't I have that?" Then he got probation
Yeah, the
for.
only documentation that I have regarding the revocation just said, revoke closed, July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008. So I'm unsure if that's an actual, revocation that was completed.
Okay, well, yeah, it sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take
So
that
he
map,
has
but,
already had
that
a
a
probation
violation was
revoked
fixed. That we don't know
once.
what that was or anything like that. All right, so does probation have a recommendation in this case?
Due to the last minute notification of this, probation revocation, I will leave that up to the courts to make that decision.
Okay. All right, well, I find there to have been,
She didn't want to make a decision. Now, we all know that probation officers, can suggest some things, especially if a client, I'm gonna say client, has not or has gotten into any more wrongdoing that is against what they supposed to comply with. Now, with being a probation officer, and I'm not one by any means, I'm just thinking outside the box. I don't know if, she would be in her legal bounds to say, well, just because he, got subpoenaed here to do this court or to testify for the state, that will be part of him in a violation of his probation, right? So I think for her to say that since this is a last minute, kind of surprisingly thing or whatever, she wants to leave this up to the court. I think that was all fair grounds, on her stating that way, because, he really ain't broke nothing that he was supposed to comply to pertaining to my office or what I want him to comply to. So, and then of course you had the state also left it into the hands of the judge to make that decision, pass the buck, as they say. They passed the buck on to her, and yeah, judge decided to go ahead and issue him 5 years. But I remember him saying that, yeah, I'm gonna go. But what I can say and agree with Lady T-Bug. Yeah, his attorneys dropped the ball somewhere. They dropped the ball, period. One, there's no way that you can sit here and try to explain what and how your client is feeling or didn't know and should have known when an attorney is there to guide you through those things on and giving you the best advice ever. But as Lady T-Bug stated that he wanted to get out. He was under pressure. He wanted to get out. He had a mom that was passing away, and he, I guess, wanted to be there. So I don't know, y'all. This case here, like I say, I just kind of dilly dab in and out of it. It's not really my forte, especially when streets and guys, and I don't want to be a person that pass judging on anybody's life. So when it comes to these type of cases and you watch people fight for their lives on the premises of being accused of doing some things, what is considered illegal in the States, I just have to, I'll be back and saying, I wish you well. Now that they are with this case here and going on so long, they have really opened the doors up to lyrics in the rap music. Maybe rap music would change after this case is done and dealt with. Who knows? Who knows? And I highly suggest that if you are a rapper and you are in a gang, that if you don't get nothing up out of this case, you got problems, because this was a whole life experience that could be your life, up in here trying to get yourself up out of a situation from the guns or from the drugs or from being one or two people hanging out on the street and considered a gang. I don't know. They found a way around it. Now, before I go, because I gotta go and get Keandre, but I'll see y'all on my team. I'll probably be on tomorrow. I got all weekend to kind of kick it with y'all because I don't have nothing planned this weekend. But um I gotta say this before I go, and it has something to do with, and I'm not getting into political views, right? Has something to do with this whole ball of Rico thing, right? Whole ball of it. Rico is just what it is. You look it up, it's gonna have the exact same meaning under it. However, that meaning is only dissected when it comes to who you are, I guess I should say, or we separate cultures. What do I mean by that? You had a president that was indicted under a RICO, okay? Under this RICO here with these young guys, right? You have Fannie Willis as the district attorney, okay? You have Love and Hilton and the other state here who works up underneath Fannie Willis, trying to continue to convict these guys on this RICO. Gang falls up underneath the RICO. You have Trump, who Fannie Willis also brought the RICO indictment on. Trump being accused of gathering so many people on a call subliminal call or blanket call or however you want to put it, that stormed that Capitol building and harmed a lot of people. However, the same people that's under an umbrella, and I'm just speaking in general, wants Fannie Willis condemned, off the case, under the case, cemented up, even in her fight against Ashley Merchant. I don't think that a lot of our Black Americans has done their research in depth on Ashley Merchant and where she got that information from pertaining to Fannie Willis and Nathan Wade. I don't. That came from Fannie Willis, not Fannie Willis, Ashley Merchant client. I think his name is Roman, something like that, right? Who brought that about. And normally when people do that, there's always an agenda behind doing such. If my attorney can bring out what I propose to her and find gatherings to blow this thing up, it's a possibility that it would take all of the distraction. I would be able to distract the world and get my case thrown out for being charged in a RICO up underneath the Trump, the ex-president Trump, and I'll be just fine. So I'm gonna push a whole bunch of chaos over there. Ashley Merchant went on about and started digging into the information that she retrieved from her client, and it exploded out here in this world. It led to, oh my God, we stumbled across Fannie Willis hiring one of her counterpartners and is also dating him. That dating scene led to investigating misappropriate usage of monies that was funded to her to bring on the Trump RICO as well as the YSL RICO. Ashley Merchant chooses to, fight her, saying that was misappropriate use of funds. Fannie Willis is out dating, screwing a man, buying luxury trips, paying for luxury this and luxury that. So now here we are out here divided in the culture and in the color of people coming, in my opinion, steaming from behind that whole block, that avenue right there. Now, if you go and you take Fannie Willis down for bringing this RICO here, right is right and wrong is wrong. So don't misunderstand me. Then you're also saying that Fannie Willis should also drop this RICO against your ex-president, Donald Trump. That's just the way that I intake that. That's just my opinion. But if she's wrong over here, then you're absolutely saying that she's definitely wrong over there. And I get it. You have a lot of people out here that is very comfortable of your president as a felon being elected as your 2025 president. You guys are very comfortable with that. But however you want these group of young Black men, some of them, they want them to remain in there. There's quite a few people that wants them to be out of there. And I understand that too. But I guess what my point is before I leave here is how it takes just one substance to happen in an area that can cause us to lose sight on the main purpose of why did all of this happen? Why is all of this happening? Ashley Merchant is being glorified for it, but Ashley Merchant will, if she succeed, be that lady that is going to say where Fannie Willis get kicked off of the stuff, you'll have probably, your first felon president who also was being charged for the same thing that or similar of what these young guys, excluding narcotics, selling, distribution of that. But kind of the same thing. That's just my opinion to how I feel about the stuff and a lot of why I refuse to dig into so much of this devilish ass shit that goes on out here. It's like damn if you do and damn if you don't, when you can clearly see where wrong is wrong and right is right. But anywho, I guess y'all got about, they said 100. I think it should be down to, from the last time that I heard them say, 100 more witnesses. Y'all should be probably down to about what, 80 now, 89 or something like that. And a whole long time from now. I had some funny shit to get into, but I'm gonna get the kids to bed, y'all. Got them tonight. And I just kind of wanted to chit chat and come in and say hello to my chat. Listen, don't forget, like, share, subscribe to the channel. Stay tuned because I'll be back. I gotta get into my funny shit, y'all. I like the funny mode, not the depressing mode. Later, Gators. Y'all have a good night.